Everyone, welcome. I'm delighted that you're all here for our Rappaport Forum on educational opt-outs after Mahmoud versus Taylor. As some of you know, the Rappaport Forum was created in 2020 to promote and model full, vigorous, and civil discourse on complex and challenging issues facing our community, our nation, and the world. Funded by the Phyllis and Jerome Lyle Rappaport Foundation, the forum honors its namesake, the late Jerry Rappaport, who as a 1L here back in 1946 established the original HLS Forum. I want to once again thank the Rappaport Foundation for supporting this vital effort to, as Jerry once put it, quote, to model a process that is core to our democracy. I also want to recognize and thank Janet Asurkoff and Jim Siegel from the Rappaport Foundation for joining us today. Please join me in welcoming them. We could not do this without your support and the support of the foundation. We really appreciate it. My main duty is happily a brief one for all of you, which is I am here to introduce our amazing and wonderful moderator, my colleague Laura Weinreb. Professor Weinreb is the Fred N. Fishman Professor of Constitutional Law here at Harvard Law School and the Suzanne Young Murray Professor at the Radcliffe Institute for Advanced Study. An extraordinary scholar and teacher, Professor Weinreb is the ideal choice to guide this discussion of educational policy, parental rights, and the First Amendment. In her own work, she studies how social movements have transformed constitutional categories to pursue political and economic change. Her scholarship explores a wide range of subjects in American legal history, as well as constitutional law, labor law, and literature. Her award-winning book, The Taming of Free Speech, America's Civil Liberties Compromise, traces the emergence of a constitutional and court-centered concept of civil liberties during the first half of the 20th century. This work was acclaimed in the Wall Street Journal as, quote, utterly brilliant, unquote, and, quote, an extraordinary reminder of why history matters to the present, unquote. Not bad. Okay. And lastly, please allow me to give my thanks to today's panelists. We have with us, as you'll hear more about, Justin Driver, the Robert R. Slaughter Professor of Law at Yale Law School, and remotely, Douglas Laycock, the Alice McKean Young Regents Chair in Law Emeritus at the University of Texas at Austin, and the Robert E. Scott Distinguished Professor of Law Emeritus at the University of Virginia. Thanks to all the faculty and staff, including the committee for selection of Rappaport speakers, for making this happen. So grateful that we have this opportunity, and I will turn things now over to Professor Weinreb.
Thank you, Dean Goldberg, for that introduction. It is an honor to moderate today's conversation, and I shared the Dean's gratitude to the Rappaport Foundation for making this afternoon possible. As you heard, the Rappaport Forum exists to model vigorous, thoughtful, and civil discourse on difficult questions. And we have a quintessentially difficult one today. Earlier this year, the U.S. Supreme Court decided a case that has become a flashpoint in debates over religious freedom, education, and parental rights. In Mahmoud v. Taylor, a 6-3 majority held that a public school district must allow parents to opt their children out of instruction that conflicted with the family's religious beliefs. The case arose from a Maryland school district's decision to introduce LGBTQ inclusive storybooks into the elementary curriculum without allowing opt-outs, a move that some families of faith argued infringed their First Amendment rights by forcibly exposing their kids to ideas that contradict their religious beliefs. This issue is controversial because it forces us to ask a fundamental question. How do we balance the free exercise rights of parents with the educational mission of public schools in a diverse society? Supporters see the court's decision as an affirmation of parental authority and religious liberty, ensuring that families can teach their values without state interference. Critics worry that broad opt-outs could undermine inclusive education, stigmatize some students, and crucially prove unadministrable, If every objection becomes an exception, they argue, schools risk sliding into self-censorship and losing the coherence that lets classrooms function. So in short, one side celebrates Mahmoud v. Taylor as a victory for religious freedom, while the other warns it impedes democratic decision-making about the curriculum and the ability of the schools to do their jobs. Both insist that their path best honors pluralism and is best equipped to create welcoming classrooms for all students. Mahmoud v. Taylor is the latest chapter in the Supreme Court's recent expansion of the Free Exercise Clause, and educators and lawmakers are watching not only how it will shape curricula and notice and opt-out policies in schools nationwide, but also whether its principles will extend beyond K-12 education. It's exactly the kind of complex, high-stakes issue the Rappaport Forum was designed to explore. So to that end, we are extremely fortunate to have two very distinguished scholars whose perspectives will help us understand why this case is so important and so contested, and where the law may be headed. Both filed amicus briefs in Mahmoud v. Taylor, Professor Laycock in support of the parents, and Professor Driver in support of the Board of Education in a brief that was cited in Justice Sotomayor's dissent. I'll introduce them in the order in which they'll be making introductory comments today. So Professor Douglas Laycock is one of the nation's foremost authorities on religious liberty. He's the Alice McKean Young Regents Chair in Law Emeritus at the University of Texas and the Robert E. Scott Distinguished Professor of Law Emeritus at the University of Virginia. Over his decades-long career, his scholarship and advocacy have played a pivotal role in shaping religious freedom jurisprudence. He's served as lead counsel in multiple Supreme Court cases and filed dozens of amicus briefs, helping to shape landmark decisions on the religion clauses. Justin Driver joins us from Yale Law School, where he is the Robert R. Slaughter Professor of Law and a leading scholar of constitutional law, particularly as it relates to education. Professor Driver is the author of two very influential books on constitutional law and education, his award-winning 2018 The Schoolhouse Gate, and hot off the press, The Fall of Affirmative Action, which is already reshaping debates about racial diversity in higher education after SFFA. Needless to say, we are extremely fortunate to have these two speakers in conversation today. Our plan is as follows. Each panelist will offer about 10 minutes of introductory remarks to frame what's at stake. Doug will begin, and he will take a few minutes to explain the case for those of you who haven't read it, as well as some of the relevant doctrine. And Justin will then offer his perspective. After that, I'll moderate what I know will be an engaging, substantive, and lively discussion, and we're going to reserve some time at the end to take some questions from all of you. So with that, Doug, could you please start us off?
I'm very sorry I can't be with you in person. I was too sick to travel yesterday, and it's much safer for all of you that I'm not breathing in your air. I will do the best I can remotely. So let me say a little bit more about the facts of the case. Montgomery County, Maryland is the DC suburbs. It's a very large school district. And the school board decided to introduce LGBT issues into the language arts curriculum in K through 5, 5-year-olds to 10-year-olds. And they began with 7 books. The 2 most controversial and most difficult to defend were dropped in the course of the litigation. The 5 remaining are not sexually explicit. But they were explicitly addressed to LGBT issues. 2 of them culminate in same-sex weddings. 2 featured protagonists who were trans children. One trans boy said to his mother he didn't want to grow up to look like her. She had to help him become a boy. And the 5th featured a puppy love romance between 2 little girls. Initially, parents were allowed to opt their children out of discussions and readings of these books. But in the school board's view, too many parents exercised that right, so they eliminated it and no more opt-outs were permitted. The school board said part of the purpose was to, or maybe the purpose was to ensure that children from gay and lesbian and trans families were reflected in the curriculum. The guide to teachers also said that the goal was to, quote, disrupt student views about sex and gender. So 4 families from 4 different faith traditions filed suit under the Free Exercise Clause seeking an exemption. The doctrine concerning religious exemptions has become complicated and isn't really our concern here, but when a religious practice is substantially burdened in certain kinds of ways, believers and institutions are entitled to an exemption from the law unless the government has a compelling government interest in withholding that exemption. And the court said this fit within one of the ways. I don't think that's, I'm happy to talk about the issue, but I don't think that's our primary concern here. So the claim was these books undermined the religious teaching that the parents were trying to instill at home, and parents were entitled to an opt-out. The 4 families withdrew their children from public school when the opt-out was repealed, and at considerable expense sent their children to private school. They said they would return if the right to opt-out was returned. District Court in Maryland denied a preliminary injunction. Fourth Circuit denied a preliminary injunction. The Supreme Court reversed 6-3 on the usual ideological lines. I do not like much of what the current Supreme Court majority does, but I think that they got this one right. And as Laura mentioned, I was the lead amicus, but not the principal drafter on an amicus brief supporting the parents. My view has always been that civil liberties must protect everybody, including both sides of the culture wars. I filed amicus briefs in the Supreme Court, spent a lot of time working with legislators over the years, urging them to protect same-sex marriage and to include exemptions for religious dissenters. Sexual orientation, gender identity, and religious belief and commitment are all fundamental to human identity. They are hugely important to the individuals who care about these things or experience such things. The government's reasons for interfering are generally much less important than these things are to individuals. They all deserve protection. And far too many people on both sides of the culture wars want maximal protection for their side and minimal or zero protection for the folks they disapprove of. So my starting premise is we need to protect both sides in such cases. The parents did not ask that the books be dropped from the curriculum. They did not ask that they be removed from the shelves in the library or from the shelves in their child's classroom. They only asked that when the books were discussed or read aloud, their children be excused. The defendant said, the dissenter said, the lower court said, and Justin said in his amicus brief that this case was only about exposure to ideas you disagreed with, and mere exposure is not a burden on the free exercise of religion. No one was required to change their opinion about sexual orientation or gender identity. No one was required to do anything that violated his religion. That's one of the arguments, actually, it's been around for a while, one of the arguments that the 19th century Protestants made in disputes over reading the King James Bible in public schools. Catholic children who refused to read what they called the Protestant Bible were beaten and expelled for refusing to read it. There was mob violence. There were riots over this issue. School officials said Catholic children don't have to believe it. They only have to read it. And it's one of the arguments in modern Establishment Clause cases about school-sponsored prayer. Dissenters who don't want the prayer, don't want to participate in the prayer, don't have to believe in it. They only have to sit there quietly or stand quietly and listen to it. The Supreme Court majority in Mahmoud took the case as the school board and the dissenters presented it. They treated it as only about exposure. And they said exposure is a burden on the free exercise of religion when it undermines what the parents are trying to teach at home. And if it's not justified by a compelling government interest, it is unconstitutional. I think they might also have said, and I think they should have said, that Montgomery County did require parents to do things that violated their religious faith. These parents believed that they could not knowingly expose their children or allow their children to be exposed to these materials at this age. There's nothing unusual about that as a religious belief. Many religions have taught and do teach that you should avoid exposure to books and other materials that are inconsistent with the faith and that may tempt you away from the faith. There are many reasons, of course, to disagree with that teaching. We may think it's better to read a wide range of materials that you agree with and disagree with, but these are quite traditional religious teachings. They're protected by the First Amendment. So its only exposure was one of the defenses. The second defense was chaos is going to ensue. All kinds of nutty religious zealots will demand opt-outs from all parts of the curriculum, and the schools won't be able to cope. Well, we will see. If it happens, schools will be able to prove a compelling interest in narrowing the opt-out right to some manageable bounds. But for now, that claim is completely speculative. Schools individualize curriculum for all sorts of reasons. They're required to do it for students with disabilities. They're required to do it for students who are just learning English. Many states, most states have legislated a right to opt out of sex education. Many states have much broader opt-out rights on the statute books. Montgomery County had a generally applicable right to opt out of anything in the curriculum before this dispute arose. And then they largely repealed it in response to the litigation. I'll tell you just about the one example that I know best. Texas enacted a generally applicable right to opt out in 1995. Opt out of anything in the curriculum. The only restrictions were you cannot opt out of a test and you cannot opt out of the entire semester of a course. But you could opt out of any subject matter. There are no reported cases. There is no attorney general opinion. There are 3 administrative decisions in the Office of the Commissioner of Education in 30 years. The general counsel to the Texas Association of School Boards says the right to opt out has been a nothing burger. Now, the Supreme Court case gets more publicity in the state statute, but there are plenty of religiously conservative activists in Texas to promote and publicize this statute. The only basis in experience for predicting some larger number of opt-outs is the large number of opt-outs in Montgomery County in response to these 5 books. I haven't been through the record. I don't know how many opted out. All we know is the school board said it was too many. I don't know if they thought it was too many because it was administratively impossible to deal with it, or if they thought it was too many because it was undermining their goal of disrupting traditional religious teachings on sex and sexual orientation and gender identity. But a larger number of opt-outs and a larger volume of controversy is what you get when you attack core religious beliefs of our largest religious minorities. Formerly a majority, but now clearly a minority in blue and purple states, which is why they keep losing on these issues politically and have to resort to the courts for protection. So, that's why so much of free exercise litigation, the publicized part of free exercise litigation in the last 10 or 20 years, has focused on conflicts between gay rights and free exercise. It's actually a small fraction of all free exercise disputes, but it's the one that draws the most publicity, and it has been recurring because for the first time on these issues and also on abortion and contraception, for the first time we're legislating against teachings of very large religious minorities. Finally, the school board says it's important to teach tolerance. Well, of course it is. and they can teach tolerance. They can teach respect for other children. At the K through 5 level, that's mostly just a matter of being nice. As children start to ask questions, as they get older, that kind of teaching can become more explicit. These people may be doing things you don't approve of, but they are entitled to do those things. They are protected by our law. They're entitled to fairness and equality, and you have to treat them that way. You can treat all of that and teach all of that without saying, and you're wrong. You can disapprove, but you cannot act out on that disapproval. So I think the court got this right. We'll see how it works out. I think it's going to turn out to be entirely workable. But this was a case in which a school board deliberately set out to undermine core religious teachings of large religious groups. And I think the court was right to protect the religious minorities.
Okay, thank you, Doug. And over to you, Justin.
Okay, I'm really delighted to be back at Harvard Law School, where I was lucky enough to be a student from 2001 to 2004. I revere Harvard Law School. Felix Frankfurter once said that he had a quasi-religious feeling about Harvard Law School. I am no Felix Frankfurter, but I know what he meant. I'm especially delighted to be doing this with Doug Laycock. I wrote a book a few years ago about students' constitutional rights. I sent my chapter on religion to Doug. Doug set aside his own work and engaged with mine as though it were his own, and he made it better. And I'm very grateful for him to be in conversation with me. We disagree, of course, but we're going to be friends after this. Okay, so a few different things to say about this case. The one is that it is an incredibly destabilizing opinion. The lower federal courts had repeatedly heard these sorts of challenges under the Free Exercise Clause for exemptions over decades. And the lower federal courts had repeatedly, uniformly refused to accept that this was a cognizable constitutional claim deserving of an exemption. So I truly believe that this is going to wreak havoc in the nation's public schools. And the notion that we're not going to see all sorts of religious objections is belied by the record in the lower federal courts. As Doug knows, the biggest case in this area goes back to the 1980s, a case called Mozart out of Tennessee, where parents objected to the Holt Basic textbook for very young people. I'm going to read you a passage that drew a religious objection. Pat has a big book. Pat reads the big book. Jim reads the big book. Pat reads to Jim. Jim cooks. What's objectionable about that? The answer is that Pat is a girl and Jim is a boy, and this undermines the religious view that there are not sex-differentiated roles in American society. And so this was an affront to religion. There were also claims about, reading a story called A Visit to Mars, that this required sort of, witchcraft thinking. Seeing beneath the surface was something else that drew objections. And this is not an isolated incident. There's a case from 1979 where parents object to co-educational physical education classes because there are students who are in immodest attire. So one could go on and on. Obviously, there are claims about evolution, and even last year there was a claim about the Big Bang Theory, that this was a violation of one's religious views. There's a case from the Seventh Circuit in the 90s that objected to wizards, sorcerers, giants, and other unspecified creatures with supernatural powers. So this is a claim that Jack and the Beanstalk is, impermissible. There are obviously those who believe that Bert and Ernie are gay. Maybe Sesame Street is going to be violative as well. So I think we're going to see these sorts of objections in a whole host of different areas. And I also want to emphasize that this case is a betrayal of two core conservative commitments, one substantive and one methodological. With respect to the substantive commitment, local control has been a conservative sort of paramount issue for decades in this area. J. Harvey Wilkinson wrote an essay many years ago that subtitle was "The Supreme Court as School Superintendent." This is supposed to be a horrific thought that the Supreme Court is going to be fly-specking individual curricular or disciplinary decisions. And here we have invited the federal courts to get into adjudicating what is going to be permissible. And as to the methodological claim, the way that Justice Alito has written this opinion is going to invite a raft of litigation. Conservatives are often with Justice Scalia saying we need rules, right? The rule of law is a law of rules. This case involves the most sort of standard-driven approach that one could possibly imagine. Justice Alito writes that the question whether a law substantially interferes with the religious development of a child will always be fact-intensive, he says. It will depend on the specific religious beliefs and practices asserted, as well as the nature of the educational requirement or the curricular feature. It says, a court must also consider the specific context in which the instruction or materials at issue are presented. So it seems to me that this is going to invite federal courts to sort of divide who has legitimate religious views that are worthy of honoring and those who have, what the court might regard as wackadoodle religious views that are unworthy of honoring. That is a very uncomfortable place for federal courts to be, and that's why they have systematically said we are not going to pay attention to this. The boundaries of the decision are also deeply uncertain. I talked to people who run schools. October is LGBTQ plus History Month. There were schools that were thinking about coming over the loudspeaker and saying, we want to talk about a great queer individual in American society. We want to talk about Harvey Milk. Is that impermissible as a result, or do the students need to be ushered into a particular room in order to be, sort of saved and spared of that message? Fascinating question arose at oral argument offered by Justice Jackson. What about a gay teacher who has a photograph of his husband on his desk? Would a student who holds these views at issue in Mahmoud be legitimate in seeking a classroom assignment? The lawyer said, no, the teacher has free speech rights as well, but it's not at all obvious as to why that is the case. After all, reading an individual picture book is, in my view, far less of a strong statement about gay equality than having a gay teacher who's in the classroom every day. So I fear that this is going to lead to many things. Doug suggests that this is not going to lead to the micromanagement of school. They did not request these books not to be taught. But it's important to bear in mind how school districts are going to respond. They are often going to say, well, we don't need these headaches, and therefore the path of least resistance is to simply take these books out of our curriculum altogether. It seems to me that this really does run up against government speech doctrine. The basic idea under the First Amendment is that when the government speaks, it's able to say what it wants to say. You'd be hard-pressed to identify a curricular a matter where government speech is more present than in deciding what the curriculum is. But having to fear parents bringing these sorts of claims is really going to chill the speech rights of the government in this fashion. It's also true that we regard public schools as engaging in citizen formation. It's true that one of the reasons that these books exist is because they're trying to talk to people about equality and the way that different families come in different sizes. Some of the people who are with Doug, including one person who joined his brief, Professor Michael McConnell of Stanford yearn for a sort of pre-political approach. They say we should just teach children the 3 R's and get out of all of this politics. They should be selecting books on the basis of, does it help the person actually read? This yearns for the good old days of the Dick and Jane readers from the 1950s. But of course, those books contain politics themselves, including about race, gender attitudes, and things of that nature. We have seen lots of controversies about books over time, including in the 1950s. There's a book that I brought with me. We've got to have a little fun here, a little show and tell. The Rabbit's Wedding, published in 1958, that caused an incredible amount of controversy. Why? There's one black bunny and there's one white bunny. And segregationists said, oh my God, this is a disaster. They are, grooming children to think that interracial marriage is okay. And of course, you law students know that people attached religious ideas to anti-miscegenation sentiment. Loving versus Virginia includes the quotation from the district court judge saying that God put people on different continents for a reason, and this has interfering with God's plan. The structure of the Rabbit's Wedding is more or less identical to the structure of Uncle Bobby's wedding, believe it or not. At the very end of the Rabbit's Wedding, the black bunny and the white bunny get married, and then they dance until the moonlight comes up. And that's exactly the same ending as Uncle Bobby's wedding. So it seems to me that school districts have a legitimate role to play in shaping young people and encouraging their acceptance of their classmates. This is in Brown versus Board of Education. Brown says, education is the very foundation of good citizenship. Today is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. One last thing to say about this issue is the age component of this. Justice Alito has written the opinion to say that age, if you're dealing with very young children, it's a different kettle of fish than if you're dealing maybe with high school students. That's a fascinating doctrinal development. That's a line that the court has resisted adopting in the past. And it's possible that there's something salutary about that. Lower courts have sometimes said that, say, high school students should have more robust free speech rights than first graders. But the Supreme Court of the United States has not done that. And so that's just an interesting and noteworthy doctrinal development, drawing age boundaries in this fashion, saying that we need to be especially protective of young people.
Great, thank you, Justin. Okay, so there's so many threads in both of your comments that I'd like to pick up on, but I guess I want to start, Doug, by asking you, much of your argument rested on the fact that you think as an empirical matter, there won't be a flood of claims. And I guess what I wanted to push you on is if that does materialize, what is going to be the basis for managing it? You suggested it'll happen at the strict scrutiny phase. I assume it's not going to happen at the sincerity or burden analysis. What are, maybe one way of asking this is, are there particular kind of claims that you would rule out, or is it merely the volume of them, and how is that gatekeeping, how might it take place if it proves to be necessary?
Well, I think how it takes place, if it proves to be necessary, depends on, how it proves to be necessary. If particular kinds of claims are the source of the problem, then I guess we would develop rules excluding or addressing those kinds of claims. My guess is, if there's a problem, it's going to be sheer volume, and the court might deal with that at the strict scrutiny phase. It might deal with that by upping the threshold for showing a burden. The opinion says it has to be a substantial interference with religious teachings at home. That obviously has some flexibility in it. How to deal with it depends on what happens. Let me say just a word about Mozart. A group of students and I actually filed an amicus brief in Mozart in the Sixth Circuit. I've been around this issue for a long time. In Mozart, which I think of all the opinions, she sounds the craziest. They had actually worked it out within the school system. She was happy, her group of parents were happy, the school was happy enough. And then a new superintendent came in and said no more opt-outs. And on cross-examination, they led her into saying some much more extreme and crazy things. But it's not uncommon. These issues are worked out informally until some bureaucrat gets his back up and says no. But in direct response to your question, Laura, it is hard to say what the doctrinal response will be to a problem before we know what the problem is. There are a lot of varied objections to curriculum, but there have not been large numbers of objections to curriculum, even in states where the right to opt out is wide open.
Okay, great. So, Justin, I actually want to shift gears a little bit and ask you about something you said, comparing this to the speech clause and to government speech, which is something you also highlighted in your brief. And, there you frame it as, let's keep these two parallel, right? Here, I gather you're suggesting broad deference on both to government, because one way of reading the opinion would be to say, okay, let's elevate speech claims too by students who want to opt out as a sort of leveling factor. And I wanted to ask if you could weigh in on that question.
Sure. So I regard the government speech issue here as giving school districts an enormous amount of discretion as to how they shape their curriculum. There are precedents, including the PICO decision dealing with school libraries, that say school libraries and the removal of books in that context is one thing, but the school enjoys almost absolute discretion over curricular matters. That's in one of the concurring opinions in PICO. That's a slight overstatement, of course. Certainly one could not religiously indoctrinate students in, public schools. One should also thinking about the free speech idea, as the Barnett decision and the prohibition on compulsory speech. That's one of the opinions that was wrestled with in Justice Alito's opinion, where the Supreme Court of the United States says in 1943 it's impermissible to require people to recite the Pledge of Allegiance. Justice Alito sort of says we should regard this, in many respects as a free exercise claim, even though the Supreme Court of the United States, in an opinion by Justice Jackson, conceptualized it as a free speech claim, that the freedom of speech entails a corollary negative right, the right not to speak. It's important to note that in Barnett, there's no suggestion that the students were able to sort of leave the classroom or anything like that. And that is what is going to happen in these classrooms all around the nation. And I do think that the teachers have an incredibly difficult job without trying to determine which student can be exposed to which particular books. And it really is going to be extremely difficult for these teachers to be able to make this work, determining what group of 5-year-olds can be exposed to this. And I am also sensitive to Montgomery County's position that to exclude and ask children to leave the room when Uncle Bobby's Wedding is read is a difficult thing if you are from a family that assumes a family structure like this. And what is so radioactive about my family that you can't be exposed to this sort of book? So of course, students retain speech rights in school as a result of Tinker and its progeny, but the federal courts have not said that religious objections, and America is a wonderfully rich nation in religious diversity. The idea that we're not going to see a lot of claims is belied by the claims that we've already seen. So I'm deeply worried about our public schools and their ability to function. And there are those who attribute it to the Supreme Court view that, well, we actually want the public schools to go the way of the dodo bird. And so if there's havoc in public schools, all the better. I don't share that cynical view, but that view is out there.
Okay, so I want to give Doug a chance to respond to that, but first, can I just pick up on something you just said there, which is we have this wonderful diversity of religious views in the United States. One of the arguments, obviously, that the parents are making is that in order to stay in the schools, it needs to be made into an environment where they feel comfortable and that they feel that their own religious beliefs are not being violated, and that one of the sort of arguments for allowing opt-outs is it will allow for greater encounters between different kinds of kids of exactly the kind that you're proposing. Do you have concerns about, in a world without opt-outs, whether that would be a real consideration?
You know, the issue of religion in public schools has been among the most divisive in our nation's history, going back at least to the early 1960s and the Engel and Schempp cases, where people are deeply concerned about getting rid of opening prayers in schools. People say, what could a school be without prayer? Over time, over the last couple of decades, the Supreme Court has, in my perspective, offered a detente in this hot button area, including making it clear that public schools are not God-free zones. As a result of the Wallace versus Joffrey decision, a lot of public schools have moments of prayer, and I have it on good authority that students sometimes say prayers to themselves before tests. There are another important part of this issue is the rise of homeschooling. In the aftermath of the Mozart decision, Robert Ferris, the president of the Homeschool Legal Defense Association, said every born-again Christian should take their kids out of the public schools. And homeschooling spiked in the country in really significant ways, and that served as a release valve for these claims. And so the idea that, well, we haven't seen these claims in relatively recent vintage, an important piece of that puzzle was because homeschooling has increased in really significant ways. And the last part of this detente is the Zellman versus Simmons-Harris case, making it clear that, indirect funding can go to schools. I'm really worried that this issue is going to bring back divisiveness to our public schools, and the Kennedy versus Bremerton school district decision, the praying football coach case, is another one of these cases that has increased the level of sort of acrimony and dissension in our public schools.
Okay, great. Doug, can I ask you to respond to that, and also, in so doing, to think about this question of the stigma imposed on the children whose identities are essentially being told they're religiously objectionable, whether, first of all, that undermines some of the pluralism ideals that you're hoping that the decision will effectuate, but also whether that potentially, given the age of these kids and the other considerations about their impressionable natures, whether that could ever furnish, you think, a compelling government interest, when the facts arise in further challenges?
Well, many millions of Americans disapprove of either one side or the other in these kinds of disputes. Evangelical Christians are not popular. They're disapproved of, they're stigmatized. Gay and trans kids are disapproved of, and they're stigmatized. Neither side is going away. We have to live with each other. And you cannot entirely shelter even little kids from the knowledge that some people disagree with them or disapprove of them. The stigma argument really runs in both directions. And it is stigmatizing for the kids who opt out to leave the classroom and sit out in the hallway too, which deters a lot of parents from asking for opt-outs. So, I think we have to deal with this and deal with it to some extent in the same way in both directions, right? You explain to one side who asks the question, why are they leaving? Their parents have a different set of views. They disagree with what we're doing here. They're entitled to that. You don't have to agree with them or approve of it, of what they're doing. Let's get on with the story. I don't think we can manage that social conflict by saying the school was taking one side and protecting those kids and suppressing the other side and trying to undermine their parents' teachings.
So that actually brings to mind a question that was sort of both in Yoder and in Mahmoud was sort of set to the side, which is how do you manage the potential conflicts between what children want and what might be best for children in the classroom environment and their parents? This is framed as a parental rights case. Is that the right way to think about this, given that what we're really talking about here is the education of children? I don't know if, Justin, do you want to start on that one?
Sure. The Yoder case is an incredibly important one for the Mahmoud decision. The lower federal courts had said that Yoder, which involved an exemption from attending school beyond age 14, in effect, for the old order Amish, and the Supreme Court of the United States says that that is constitutionally required. The lower federal courts have said that that had basically no import for these sort of curricular opt-outs, and you could imagine why that would be. The old order Amish were, Chief Justice Berger's opinion says in Yoder, a completely self-contained group. They were not trying to, enter the larger American society. They were not on welfare. It seemed very tailored to the particularities of the old order Amish. And it's also true that the exemption that they sought was a complete removal from school rather than the sort of picking and choosing of what books could be exposed to, which places incredible administrative burdens on the school. Our former colleague, Professor Emily Buss, wrote a wonderful law review article titled, "What Does Frida Yoder Think?" The import of that is it's tempting to think that parents and their children are in complete alignment on these issues, but it's quite plausible that the parents and their children are at loggerheads on these issues. I have my real doubts that the Yoder decision was correctly decided at all. I write about this issue in The Schoolhouse Gate, the book that came out in 2018. I found some quotations from Jonas Yoder himself, who says it costs us a lot of money to send them to beyond the 8th grade to school. He's not talking about sending his kids to private school, obviously. He's talking about the money that it costs them not to be laboring on the farm. And the idea that depriving your children of a high school education is essential for maintenance of your religion raises real difficulties for the Frida Yoders or the other Yoder children who are being enlisted for their labor. So I think it's quite relevant to say that sometimes the students are going to be at war with their parents.
Great. Doug, do you want to respond to that?
Well, I think that's right at the high school level. It's much less right at kindergarten through 5th grade. I also have my doubts about Yoder because the exemption was so sweeping. But I've always thought really the key to Yoder was how little Wisconsin required. The Amish sent their kids to school through 8th grade. Wisconsin required them to attend school through to age 16, which is typically in the middle of 10th grade. So we're talking about a year and a half. And in terms of the kinds of children who wind up going to the Harvard Law School, it's utterly ridiculous to drop out of school at 16, and it's utterly ridiculous to drop out after 8th grade. And the extra year and a half really doesn't make any difference. And Wisconsin could not show any kind of compelling interest in that year and a half. I don't know what we do about the parent-child conflict in high school. The traditional legal rule has been the parent rules until age 18. The court had carved out some exception to that in the abortion area. That's gone now after Dobbs, although it survives in state law in some states. Maybe we'll have to do something similar with educational conflicts in high school. We don't have much doctrine or track record of actually trying to do that.
Great. Well, I have many more questions, but I promised to leave some time for all of you. So I wanted to see if there's any audience questions that we can bring in with our remaining 10 minutes here. Yeah, Omar.
Hello, thank you both for being here. Professor Driver, you talked a little bit about the détente between the free exercise clause and public schools. In light of Mahmoud, the anticlimactic 4-4 affirmation of the Oklahoma charter school, and the likelihood that the Supreme Court addresses 10th Amendment cases in schools in the next few years, would you say that the détente is holding, or where do you expect the relationship between the free exercise clause and the public schools to go?
Yeah, I think the détente has been broken, and I wrote an article a few years ago in the Harvard Law Review called Three Hail Marys that talks about this fractured détente as a result of the Kennedy versus Bremerton School District decision. I was fine with the Carson versus Macon decision, which honored the détente. I do believe that obviously a large project of the Roberts Court has been to bring the free exercise clause to center stage and to relegate the establishment clause to the wings. I fear that that project is going to continue apace. Indeed, as you suggest, there are many states that have said we need the 10 Commandments in our classrooms in direct contravention of a Supreme Court decision from 1980 called Stone versus Graham out of Kentucky that said it violates the Establishment Clause to post the 10 Commandments. One might imagine that this Supreme Court is going to say, no, we shouldn't regard this as a form of instruction. We should regard this as a passive display. And there are lots of secular reasons to have the 10 Commandments in school. So I think that this détente is broken, and I'm sorry to say, especially optimistic about it being pieced back together.
Doug, did you want to respond to this as well?
I totally agree on the Establishment Clause side. I've filed amicus briefs in the 10 Commandments cases in the Fifth Circuit.
All right, great. Yes, please.
Hi, I just also want to thank you both for being here. My question relates back to what you were talking about earlier, of exposure as a burden on religious values. The examples that you mentioned, Professor Laycock, of Catholics being exposed to the King James Bible and the exposure to prayers of another religion burdening one's own religious values. How does that change when the exposure is to a secular idea, like the same-sex marriage in Mahmoud? And where is the off-ramp when you go down to other subjects, such as exposure to biology burdening the belief in creationism, or exposure to, and I think this was a question at oral argument, exposure to a biography of a successful woman in employment as burdening the religious belief that women should be in the home?
Yeah, good question. So when the material is explicitly religious, we're on the Establishment Clause side. And there the court has said, and I think correctly, opt-out doesn't fix it. It's just not the school's mission or responsibility to teach about religion. Government's supposed to be neutral about religion. When the material is not explicitly religious, when it's secular, now we can only be on the free exercise side. There are all kinds of secular instruction that touch on somebody's religion. So the answer cannot be that we just don't teach any of those things. The answer has to be when there's, when the burden is sufficient, the answer has to be a right to opt out. And, as Justin said, the courts, the public schools won these cases. There weren't that many of them, but there was a steady trickle of these cases for 40 years with the argument that public school is all or nothing. You can opt out and go to private school or homeschool, But if you come to public school, you have to take the whole thing. The curriculum is an integrated whole, and we can't decide. And they absolutely refuse to think about this question. What are those few skills and subject matters that are so important we have a compelling interest in insisting that every child learn them? And what are the things that are less critical where we can permit opt-outs? Mahmoud may require them to finally begin thinking about that question. It's an important question of educational theory. I think there are answers to it, but they, for 40 years in the lower courts, they successfully avoided having to think about it.
Doug speaks about this isn't about exposure, and in the brief that he filed, he speaks about indoctrination. He and his colleagues write, parents have a broad free exercise right to prevent their children from being indoctrinated in beliefs that contradict their religious faith. Indoctrination is one of these words that we would do well to use less promiscuously, I think. It seems to me that if you view reading a storybook as indoctrination, then indoctrination is everywhere in our educational environments, right down to reciting the Pledge of Allegiance when children can't understand the words that they are saying invisible rather than indivisible and things like that. In high school, by the way, you can understand indoctrination as being there. If you're instructed to write an essay about a civil rights hero, and you say, I want to write my essay about James Earl Ray, the assassin of Martin Luther King Jr., surely the teacher can say, absolutely not. You can write about Rosa Parks or, John Lewis and these sorts of things. So even in law schools, by the way, it seems to me that there might be indoctrination of a certain sort, where everything's theoretically open and lively for debate, but we have the anti-canon of Dred Scott and Korematsu and Plessy, Lochner, right? Good luck really arguing that these cases are correctly decided. And conversely, Brown is our true north in our constitutional order. So it seems to me that even in law schools that you might regard a certain type of indoctrination as happening.
Great. I think we have time for one more. Back there, please.
Thank you again for being here. So the Mahmoud decision cast Yoder as an exception to the Smith rule of no exemptions for neutral and generally applicable laws. Do you think that Smith continues to survive? And if not, what do you think should replace it?
Maybe I should take that one. Smith continues to survive in part because they found so many ways around it that it doesn't matter anymore. For those who don't know, Smith is a Scalia opinion in 1990 that says there's no right to exemption under the Free Exercise Clause from any law that is neutral and generally applicable. Didn't define neutrality, didn't define general applicability, but he did distinguish earlier cases in part by saying they had at least some secular exceptions, and so they weren't really generally applicable. And as the court shifted, as the political valence of free exercise claims shifted, the court has taken that if there's a secular exception idea and run with it. And so the principal effect has been to complicate every piece of litigation. You have to start by finding the secular exception, arguing whether this secular exception is sufficiently analogous and relevant. In Philadelphia versus Spalt, they said it doesn't even have to be a secular exception. It's enough that there's authority to create secular exceptions, even though that authority has never been exercised. And in Mahmoud, they said, they didn't overrule Yoder and Smith, so education is an exception to Smith, and we don't have to explain why. The reason Scalia gave was utterly absurd, and they refused to bite on that in Mahmoud, but they said Yoder's an exception and never mind the reasons. So if you're a litigant, you can argue that Smith should be overruled, or you can argue it fit with one of the many exceptions. The word limits are pretty tight in the Supreme Court. It's kind of hard to do both. But they keep deciding all the cases under exceptions. There's not much left of Smith. Sooner or later, they might overrule it, or they may never have to. It may just kind of float along as the hollowed out rule for a long time.
Well, I think we may have found a point of agreement to conclude on. So I want to thank the Rappaport Foundation. I want to thank all of you for joining us, and I especially want to thank Doug and Justin for really thoughtful and stimulating discussion, and one that truly modeled the sort of respectful dialogue that the Rappaport Forum is designed to promote. So thank you all.